Hello, everyone. Thank you for joining us today. Thank you, Ma. Mrs. Uche is with us today. We're very grateful. Thank you for joining us. Hi, Don. Hi, Maggie. I think you showed your face earlier. Hi, Maggie. Thank you all for joining us early this week. How
Thank
was
you.
your week?
I
Yes,
guess
ma'am.
I guess the same. I mean, the same routine. So nothing really very eventful. Just same old routine.
Oh, okay, ma. Thank you very much. You're looking very casual and relaxed and
Yeah,
good.
today is Friday, so we dress down.
Thank you, ma. How are you doing, Don? How are you, Maggie?
I'm fine. How are you, Juliana?
Fine, thank you, Maggie. How are you doing, Don?
No, I'm very well.
Ọjọ́ àná ló ṣe lò drop ẹ̀ sí WhatsApp. So gbogbo iṣẹ́ tó ń ṣe báyìí sí tó fi sí WhatsApp rẹ̀ tó bá ṣẹlẹ̀ sí wọn á take time kó tó reach them.
Um, okay, so we'll be starting very soon. As you know me, my name is Juliana, and I'll also be your anchor for today. Um, so let me just briefly say what the program is about. So Jiipcc Mentorship and Internship Program is a quarterly intellectual property mentorship program for law students, young lawyers, and intellectual property enthusiasts around Africa. Mentees are afforded the opportunity to access valuable intellectual property advice, training, network, and mentorship from experienced IP mentors. This program seeks to encourage continuous intellectual property training, development, and evolution in Nigeria, Africa, and around the world. Part of our objectives is number one, to provide easy access to intellectual property guidance, training, and resource materials for students, young lawyers, and IP enthusiasts in Africa, to facilitate dialogue and network among experienced and less experienced intellectual property practitioners and stakeholders, to transform mentees into intellectual property mentors and leaders for the next generation of mentees, to facilitate their intellectual property mentorship, internship, scholarships, and IP related job placements for the mentees. So for the mentees that we even worked with for the first quarter, some of them have volunteered to work with us in this current quarter. So it's important that those who come in as mentees grow to become mentors for others. And so we'll be starting now. I'll advise that when I call you, you introduce yourself, your name, your country, and then if it's possible for you to share your screen, we would really appreciate that. Thank you, Mr. Marx, for joining us. We appreciate your presence. So we'll be starting with Dawn. Hi, Dawn. Can you start the presentation for us today?
Afternoon. All right. Yes, I will be sharing my screen. My name is Dawn Nosyoa from Nigeria.
What's your topic for today?
My topic is content creation and intellectual property, the effects.
Okay.
Please call me. Let me share my screen. Oh my God. Please, I'm having challenges sharing my screen. Let me just, I'll continue as I go on.
Okay. That's fine.
Okay, thank you.
Hi, John. We are still waiting for you. You can begin your presentation.
Okay. Please, I'm sorry for the delay. Okay. So, can you hear me?
Yes, yes.
All right. Thank you. So, I checked on definitions of content creation, and according to Wikipedia, it's an information to, it means the contribution of information to any media, most especially digital media. And we've seen over time on social media, some people come out and say, oh, I'm a content creator, but it's not as serious as people make it to be. It's just, it's as easy as you drafting something on your computer and sharing it online. Whether videos, uploading videos, or making tweets. So then there's this general belief that, the internet is a free place. You can impute anything there, and it doesn't matter as far as what I'm uploading doesn't offend anybody. But the truth is that it actually goes beyond that. Sometimes we copy people's works and upload them online, and we assume they are ours, but those were actually contents that some other persons created. And over time, some people have took offense to some of these things. So, for example, when you open an account, which everybody does on Instagram, Twitter, Facebook, we usually do not go, we don't check some of these terms and conditions. Most times we just click agree and we just, oh, it's so lengthy. Even the same with bank transactions, we just click agree. But the truth of the matter is that when you agree and you go through some of these terms and conditions, I took my time to go through the terms on Instagram, and it's expressly stated there that whatever content you create on their platform belongs to that platform. So you can't come out and say, oh, that's why most times you can actually screenshot people's posts on Instagram or some other platforms and then upload it, and it's not seen as an offense because that's work. You've actually given them license to use your work or for your work to be used on that platform. So it's actually not a violation of your intellectual property rights, but there are actually ways that you can protect your content, because content is actually very, very important, especially to business people who take time out to create content to push their businesses and all. And some of the ways that we can protect our content are that you can expressly state on your work that this work is your original work, it belongs to you. You can put the copyright symbol, that's the C symbol, and possibly the year of creation. So when people use it for something big, you can come out and say, oh, you didn't seek for my permission. And also it would prompt people when they see that, oh, this thing is really has this originality and oh, this person doesn't want people misusing it. People would want to seek for your permission before they make use of such content. And then you can also add digital watermarks to your works. Like it makes the video of low quality, and when people want to copy this or want to screenshot this post and make their own post, they would not be able to do so because obviously the quality of the pictures would be of really low quality. Then you can also link your images and videos back to your website, because now it takes them back out of that particular platform to your website where you have your own terms and conditions drafted. Then you can also keep track of the contents that you publish. So when somebody does this, you can always go back and say, oh, I think I noticed that my work, my content, the rights of my content were actually violated. I cited a case on my report in 2017 where a t-shirt worn by an artist in New York had an inscription, "Why be racist, sexist, homophobic, or transphobic?" It was actually a tweet. Now, this is a certain company took this tweet and then imprinted it on a shirt and started selling. And they had already sold about 5,500. The person actually took offense because he felt, oh, this is my work and you're making money out of it. So it's as serious as that. And the importance of doing this as a business owner is that saves you a lot of trouble. Like when you know your rights, that you have rights to your content that you create, can actually prosecute these persons. It actually tells you that you can grant licenses to these people to make use of your work. But there are actually exceptions where people can make use of your content without actually seeking permission or infringing on your rights, such as when they use it for non-commercial purposes or for research and reporting and all. So that's it. Thank you.
Okay, thank you very much, Dawn. Beautifully presented and written also. I think I went through your work and I agree that it's very easy to put a lot of content online. So you just pick up your phone and you put it and all that. But the parameters that you stated for also protecting it, it's very, very important. So thank you for your presentation. I'll be calling on
Thank you.
Kay to give the first comments to your presentation. You're welcome, ma.
I don't think I heard you. Sorry.
Myself. Sorry, I was introducing you to comment on her topic, ma. Can you hear me?
Okay, I can hear you well, but I don't know whether I didn't know, I thought you said Charles.
No, no, no.
Oh, you meant me?
Yes, ma.
I'm so sorry. Oh my God. I'm so sorry. All right. So thank you so much for that fantastic presentation. And because awareness is key. So what she has really done, she has taken the pain to highlight what maybe the creators of work should look at, especially when they're out in the space on Instagram. But the only thing I will advise, like in law, they say, buyer beware. I think once anything you don't want people to abuse, don't put it online because it will go places. People, once it's out there, there are a lot of criminally minded people that are looking to either steal the work or kind of use negative connotations about stars and then turn. There have been instances where they used people's faces on somebody's body. So all of those. So, but it's important that she mentioned that you have to get an agreement because that's the only way you can have recourse in court. So don't be in a hurry to put it out there. Before you put it out, make sure you have taken that you have taken time to keep your house in order. Then her final point about an exception to where to use of somebody's work in instances where you can use it without permission. And then she mentioned non-commercial use. Yes, but it also opens the door for abuse because non-commercial use, I tell you that I'm using copies of your work and I will print extra copies for the library use or for the students. And then who goes, and there should be metrics, who goes to really measure and see what the number of that non-use. So that is really open to argument, and a lot of people, one has to really look at it holistically to see, before you commit to that. And then again, if you say for non-commercial use, yes, non-commercial use, but I can use it to make myself famous. I haven't gotten money from it, but I've gotten fame, because if I put it online and say that I'm doing for charity, for instance, and I want to give it to a particular college at no cost, but then it goes down in history that I'm very charitable, that is me. So you go into my profile, what I'm doing as a good corporate citizen, if it's a company, or even as a person, that you're an influencer or you're a champion, you're encouraging law students. So I guess everything has to be looked on a case by case. Just don't have a blanket rule. Look at each one, because in the past, when the laws were drafted, people were more, let's say, kind and businesslike and honest and responsible. Unlike now, everybody's looking for every loophole to reap where they did not sow. So that's my 2 cents. Thank you so much.
Thank you very much, Ma, for your contribution. We'll be calling on Mr. Marx to also contribute.
Okay, thank you, Juliana. And it's good to be here again today. I wanted to just make a comment before I make my comment. I think, Juliana, maybe you got the order not too right. I believe Ms. Nwokocha should have commented after I did. The reason is that, when the magistrate court gives a decision, it goes to the High Court, to the Court of Appeal, before it gets to the Supreme Court. So at least it's good that when she's making her comment, she'll also be commenting on my own comment as well.
Okay, all right. In that case, I want to digress and say that every time we hear from you, you are in this your regalia on a Friday going somewhere. So where are you going to today? I mean, life must be good where you are.
Well, Fridays, maybe I'm just doing thank God it's Friday, ma.
Okay.
So thank you all.
Driving, so I thought that she should speak first, thinking that you would have gotten to the destination before
to my destination. Okay, no trouble. I'm good. We'll keep talking, even though I'm kind of on the road. But don't worry, I'm safe. So we'll keep talking.
Okay, sir. Okay, thank you.
Okay, so thanks. Yeah. So and thank you, Don, for your presentation. I enjoyed it, and I think it's a very relevant topic at the moment because content creation actually has itself become a huge industry at the moment. So lots of people are thriving on nothing else but creating content, and it comes in all shapes and sizes. Even regular business activities now find a new income stream by recreating what they already have and fitting it to become content for use on new and different platforms. So that itself has become a very important business model in this generation. But one point I would just like to highlight, and which I would encourage you Don to look up a little bit more on, would be looking at content creation from the collaborative perspective. Because in the digital world, we have realized that increasingly it's more important to collaborate. And then there are times when you just can't do without collaboration because some projects are kind of large. So it becomes wiser to put forward a collaborative approach where you are, in a sense, crowdsourcing other contributions to improving your product or your service. So one simple place would be software development, for instance. So using some of the new licensing models we have now, like the free and open source software licensing model. So you could read up a little bit more on that. It just tells how you could allow people to use your copyright. There are still restrictions to how they use it, but at the same time, you are allowing it to be open enough for others to collaborate on. Of course, there are some dangers using free and open source software, because if you do that, then it means your own software also under the terms of the free and open source software license also become free and open for others to also use. But the advantage of that is that with free and open source software, so many people can work on the same software and keep improving it until it gets better. So for instance, Android is one example of a free of a software licensed under free and open source software framework. Then for other kinds of copyright works also, that it typically is the subject matter of content generation. You could also license them under a Creative Commons license, for instance, which is also another collaborative platform where you allow other people use your copyright, but those are subject to restrictions. So you could restrict it to look, the person can only use it, but after attributing you as the author, or use it only for non-commercial purposes, or use it only for, or use it exactly as it is without allowing any modifications to your content. So that could be other ways to get, to do content, to do a content business in a collaborative approach. So if you look at open source, free and open source software, and look at Creative Commons, I believe it will expand your view also on content creation. Thank you, Juliana, back to you.
Thank you. Thank you very much, Don. So I'd like you to also go and read about open source, copyright, copyleft, Creative Commons. Then you can also look into the collaboration that Mr. Marx spoke about. So we see that a lot of people use people's content inside their own content. So if you listen to Lastis's jokes and everything, there are sometimes that he actually puts songs into what he's doing, other people's songs into what he's creating. So if you check on YouTube, go to any person that creates content, you would just click on their YouTube page, that particular video, click on it, you would see the works that they use that are not theirs, that is already registered with YouTube. So that's what YouTube does to still incentivize those people that they are using their work. But for some other platforms like Twitter, etc., they might just bring your content down. But for YouTube, they have a way of monetizing it to still pay the people that you've used their own material in your work. So thank you for your presentation. We'll be calling on Adetola for her presentation now. Hi Adetola, please introduce yourself, your topic, and your country. Hi Adetola.
Okay. Yes. Thank you so much. Thank you. Yeah. My name is Adetola Layomi, and I'm from Nigeria. And my topic is the early stage of a startup and its IP. Let me try and share my screen.
Okay,
So,
thank you.
let me try and share my screen. Okay. Can you see my screen?
I think it's still coming on, but we've not seen it yet.
Okay.
But we're seeing that you're about to. It's actually taking time. Maybe you can just start the presentation and then we'll see if it comes up.
Can we all see it now?
Not yet. Maybe it's a network issue or something. You can just start your presentation if it's not coming up. Hi Adetola. You can just start your presentation since you've not been able to share yet.
I don't know if you can hear me.
Yes, we can hear you. You can start. Can you hear me, Adetola?
Can you hear me?
Yes, I can hear you. Can you hear me?
Okay. My network is very bad, so I don't think I'll be able to share my screen. So I'll just like get on with it.
Okay,
So
that's
my
fine.
topic is the early stage of a startup and its IP. Um,
Hi, Adetola. I think you are muted. Um, Maybe we'll just move to someone else, and then when she's ready, we'll ask her to join us again. Maggie, are you ready?
Yes, I'm ready.
Okay, you can just go ahead and present while we wait for Adetola.
Okay. My network is also a bit bad, so I won't be able to share. Is
Okay,
that fine?
yes,
Okay.
that's fine.
All right. My name is Maggie, and I'm from Namibia. My topic will be running shoes and intellectual property. Probably the mentors are asking why running shoes. Ever since COVID last year, I grew a love for running. So when I was looking for my second topic, I wanted to find out how is the IP in running shoes. So I thought I should do research on the famous brand, which is Nike. So I'll be sharing the few IP lessons from Nike that I have researched about, and I'll also share the new brand that was founded in Kenya. When I was busy reading running shoes article, I came around the article under the WIPO Intellectual Property Organization magazine about the new brand called Enda. So the founder of Enda, her name is Navayalaho Osembo, and she said that in the running shoe world, everyone is trying to revolutionalize running. So there's a lot of IP. So the founders of Nike, I didn't know that they were also runners. So the runner and his coach realized that the shoes that they were running with were not very light. So they decided to come up with lighter shoes that will make it easier for the runners to run on trials or on the road. So Nike is one of the well-known brands that we all know. I didn't even know that a few years ago, I didn't know that Nike had running shoes. I thought it was just sneakers for you to walk around. And according to their statistics in 2019, their revenue was about 39.1 billion US dollars, which is a lot of money, actually more than I think one of even Africans' GDP. So the first patent of Nike was granted in 1974. And since the patents expired, they hello, can you hear me? Okay. So one of the lessons that I really learned from Nike is that they rely on design patterns, meaning that they always make sure that they do research and improve their patterns so that they bring to the market what the clients want and something that the runners out there will really feel comfortable to run in. And they also endorse with celebrities. Like we saw last week, there was a run from Eliud Kipchoge, who's from Kenya, and they also sponsor him with Nike shoes. And they really invest in their research and development. Nike's IP watchdog is very they know their IP, so that's why there's a lot of IP cases with other brands. Like there's also one of the recent brand is Nike with malicious mischief, where they say that they use their trademark with the shoes called certain shoes, and Nike feel like they are diluting their brand because people will feel like they are associating their brand to satanic things. So they did put in an IP case. It's a new case because it was just filed now in March. And in 2020 last year, they also had a case with Adidas. In 2019, they also had a case with Skechers. And in 2018, they also had a case with Puma with regards to patent infringement. So from this, I really got to know that their legal department really know what is their right. So that's why that even though other shoe companies go out and infringe, they know that no, this is our product, and no one can just go in the market and infringe our product. The Ender product that I was talking about that was established in 2017 has a really good brand. I even ordered my shoe. I'm waiting for it to arrive. I think it will arrive next week, just to test it out. So I thought they could really learn a lot from Nike. Because it's a new company and they say they registered their trademark and their design pattern as well. And they also, I like the fact that it's a young company and they really know the importance of IP and that they really have registered IP as well, which is a good thing for Africa. I think the only thing that they need to do now is really a network with famous runners in their own country so that they can expand their brand. Because I think it might be really a good opportunity for Africa to be out there in the market, because now we rely on American brands, but I'm glad that we have an African brand that is coming up, which is Ender. So yes, thank you very much.
Okay. Thank you very much, Maggie, for the presentation and for your love for running. Hopefully, some of us will get to run in future so that we can lose some weight.
Yes.
So, I think it's an interesting topic, and different things can be done to protect it. So we have like the name of the brand, which will be protected by trademark. We have industrial design in Nigeria that will take care of the design of the shoe, and then patent if there's any, maybe some inventions in it. So I'll just leave it here and I'll call on Mr. Marx to give his comment on your presentation.
Okay, thank you, Juliana, and thank you, Maggie, for that presentation and for reminding some of us again that we need to go and buy some sports shoes and start running before it gets too late. So I'm also in the same category as Juliana and hoping I'll do it someday in the future, and I pray that future comes soon. Interesting presentation, and I love the way you have tailored your presentation to a particular industry, and looked at a particular industry. Yeah, the running shoe industry actually is one industry that has got a lot of traction lately, and is one industry that I think maybe because of its founding members like Nike and the rest have really led to that spiral effect where most of the startups in that space understand the importance of hedging and protecting their investments with the proper IP framework, and I think it's important. Lots of industry startup, and some are maybe because the founding members of that industry don't place too much importance on IP. Somehow the others who follow up in that industry also adopt the same attitude. The only thing I want to point out in your presentation, and maybe you do some more work and inform us just for information, would be the different terminologies used in your presentation. So design patents, utility model or utility patents, and the likes. I know that in Nigeria, for instance, we don't have utility models yet. We don't have a law for that. We don't have what is called design patent in other places. We call industrial design in Nigeria. So I expect, Maggie, you are from Kenya?
Namibia.
Oh, from Namibia. Okay, so in Namibia, what is the law? Is there a law for design patents or for industrial designs? And is there...
Hello?
Yes, I can hear you, Maggie.
Oh, we have utility models as well, and patents.
Utility model and patents. Oh, okay, so there's no industrial design.
No, it's just design.
Design. Oh, okay. I think Mr. Max is having some technical issues, so maybe while we wait for him, we can hear from Mrs. Uche. You're welcome, ma.
Hi, Maggie. Maggie, thank you for your presentation. Very nice to have you again today. I remember I met you virtually last week, Friday. So well done on this well-researched topic. So I think it was Steve Jobs of Apple Inc. that said, give customers what they need before they even know they need it. So, which means that you have to do your research and know what your customers need and give them ahead of time. That way you really stay focused and stay in business. And that is the magic Nike has developed. Before Nike, there are Puma and Adidas and all of them, but Nike just came. Even look at their slogan that says, just do it. It's very inspirational. So if you're like having a problem and making a decision, and then you have a t-shirt with that and you look at it, you know, there's a way you feel. So I think they are designers, they really know what they are doing. So they come up with such taglines that people will see, and then it will motivate them to go buy the stuff. And I remember in the past, one of their slogans as well was crush Adidas. And people were wondering that, oh, this is very harsh. But now advertisement is very harsh. People just say you need to do something to be out there to sell. So it's like dog killed dog. Everybody wants to, and it's a corporate world and corporate politics. Everybody wants to make it and make to the bank, and shareholders are constantly pushing the company to break even and make profit. So when they had crushed Adidas, we thought it was too harsh. But that's exactly what happened today. They really crushed Adidas. Not only Adidas, they crushed other people in the industry, because Nike became the leading brand. Everybody wears Nike. It's like, and then for the young generation, it's their thing. I mean, it's like a status symbol. People want to wear Nike to go to after work drinks. You could just wear your all of those gear, and then when you wear any of their sports shoes that just come out, then people look at it. So you want to be the one to launch it. So it's like they're really giving the public what they want, the consumers, the customers, and just like the brand says that it delivers what it says it would. So if you really invest your money in Nike, you know when you put it on that you feel happy. So it goes without saying that the leading brand, and that didn't happen overnight. You needed to invest on your brand, advertisements, and developing them and moving and doing research to know what people want, and look at their comments, so that when people are not happy with any particular thing, you take them down, especially with counterfeiting. And then there are no corporate body wants to be linked with counterfeiting. So if people start counterfeiting Nike, it's advisable. And Nike is almost like Coca-Cola. They really have a zero tolerance for counterfeiting. So they will be on the lookout, take it down, because you don't want your consumers to buy the fake Nike and spread the word. Word of mouth is very strong, and say that Nike can no longer deliver. So it's very, very important that brand owners really look at what people say about their brand and try to improve on them. And then on the startup in Kenya, very, very encouraging. It underscores the belief that a brand that is young today and less known can become well-known tomorrow. How did the Apple of this world start? And all of them. So if you invest on your brand, you'll be so well-known. So it's really good to know that we have one of our own in Africa, so that when the after really takes hold on the African jurisdiction, then of course that will help the startup, to really develop into other African countries. Thank you so much, Margaret.
Thank you very much, Ma, for your contribution. Mr. Marx, please, you can complete what you were saying. You can finish your contribution. Sorry about the internet.
Okay, apologies. A voice call came into my phone and cut my internet connection off. So I just wanted a clarification about the terminologies, whether in Namibia they have whether the law in Namibia provides for industrial designs or for design patents, and whether they have utility models available in Namibia. I know we don't have that in Nigeria, so I wanted to just clarify that from Maggie.
In Namibia, we have utility models, industrial designs, and patents.
Oh, okay, excellent. Yeah, I just wanted to clarify that. Thank you, and it was a wonderful presentation from you. So I have nothing else to add, Juliana. Back to you.
Okay, thank you very much, sir. So we'll be moving to Sewese. Sewese, you can make your presentation. You can just introduce yourself, your title and your country, and then you share the screen if you are able to do so. Hi, Sewese. Are you with us?
Yes. Hello. Good evening, everyone.
Good evening.
Can you hear me?
Yes.
Okay. Good evening, everyone. My name is Sewese Yaji Aonu. I'm from Nigeria, and I'll be presenting on artificial intelligence and intellectual property rights. Okay, so I won't be sharing my screen, so I'll just go ahead. So I'll start with the definition of artificial intelligence. The term artificial intelligence was first coined in 1956 by John McCarthy, and he simply defined it as the science and engineering of making intelligent machines. So traditionally, it refers to artificial creation of human-like intelligence that can learn, plan, reason, perceive, and process natural language. So over time, artificial intelligence, I'll be using acronyms AI and IP interchangeably during my presentation. So IP is referring to intellectual property, AI is referring to artificial intelligence. So over time, AI-enabled systems have transcended from those simple programs that's maybe solving simple calculations to creating more complex works, that's to deep learning and all of that. So there's a question as to whether such works that have originated or have been created or invented by AI-enabled systems can be accorded any status under IP laws. So in considering that, I've also tried to highlight the advantages that AI has for IP lawyers and IP right holders as well. So for instance, with regards to trademark registration, an AI software can be used to assist trademark owners in brand creation, conducting clearance searches, identifying objections, and all of that. Then similarly, in patent registration as well, we can also use AI-enabled systems to identify relevant prior art so that the inventor can assess patentability of their inventions. So generally, AI has a whole lot of advantages to the IP lawyer, especially. So in terms of contract reviews, automated drafting and filing processes, time saving, and it's also cost effective, so many other advantages as well. So I would go straight to issues that have arisen as a result of the relationship between artificial intelligence and intellectual property rights. So we've seen that this artificial intelligence has moved to that stage where on its own, it is no longer just depending on the situation before now was a human being instructs the computer, programs it in such a way that it invents, it creates works and all of that. But we're seeing a situation on the computer on its own can go ahead to invent a work, to create a work. So that's where the issue is now. So while wondering, can these rights that have arisen from machine-created works, AI-created works, be also accorded the same status as those scripts? So I've tried to state some issues, some questions, fundamental questions that have arisen as a result of those situations, as a result of that discourse, as to whether AI would be
it's like your
should
network
the human being or the AI application be named as an inventor?
Sorry, please, is it just me or can everybody hear her?
No, I can't hear her.
Yeah.
Then
Okay.
another
Say,
question.
okay, maybe she would join us because she has left the platform. So maybe the network cut her out. So let's hear from Daniel while we're waiting for her. Hi, Daniel, are you here with us?
Yes, I'm here. I can hear you, ma.
Okay, so you can start the presentation and then maybe when she joins us, then she'll just continue.
Okay, I would just want to share my screen.
Okay.
Just a minute, ma.
Okay.
So I think I've shared my screen. Okay. So I don't know if you can see my screen, ma.
Not yet.
Not yet. Wow.
Okay, yes, we can see it.
Okay. Okay. My name is Daniel Akinwale. I'm from Nigeria, and my topic is IP protection and franchising in Nigeria. So I would start by explaining that, well, franchising enables businesses that has global reach to actually expand their brand to different countries with little or no risk and capital, but with enormous benefits. We are seeing that nowadays, like someone said now, that franchising is now having it's now becoming globally popular, and now we are also seeing franchising or franchise being set up in Nigeria. I think we have examples of Domino Pizza rather. So it shows that there is now acceptability of franchise even in the third world countries, for example, Nigeria. So then that means it is important that these franchisors protect their IP rights that gives value to this franchise. The question is, what is franchising? Franchising is an arrangement where one party, who we call a franchisor, licenses or grants another party, a franchisee, with the right or authority to use the business brand name and trademark in return for consideration, monetary consideration, which might be in a lump sum, it might be in staggered form, it might be on a commission basis. What actually gives effect to this franchise or franchising arrangement or franchising relationship is a franchise agreement, the binding documents between the franchisor and the franchisee. So it gives them, it brings or it creates this relationship. Well, Nigeria, unlike some countries, we do not have a specific legislation that regulates franchise. I think I did some little research. I think there are some countries that have, Sweden, for instance, Malaysia has, I think one or two other African countries have specific legislation that actually regulates or govern franchise. So that means the fact that we don't have a specific legislation, that means we need a franchisor might need to look at other relevant legislation that will protect their IP, and they will have to take certain steps to also protect their IP to prevent the franchisee from exercising or using the franchise without unauthorized, making an unauthorized use of the franchise, or to prevent from stretching the franchise beyond the scope of the franchise agreement. So now the question is, what are those relevant IP rights, and what are those relevant IP legislation that a franchisor can turn to protect his IP rights in Nigeria? One, the trademark or the Trademark Act. Well, all there's unanimous agreement that trademark is a territorial right. So that means a franchisor would need to register his trademark to enjoy protection of same. Look at Section 3 and Section 5 of the Trademark Act. So that it's advisable for a franchisor before creating a franchise agreement to register his trademark with the trademark registry in Nigeria to prevent unlawful use of same by third parties or even the franchisee. I think there were cases of Burger King and Taco Bell, not in Nigeria actually. They had issues. They found out while creating their franchise, they found out that their trademark had actually been used by a third party. So this shows the necessity of registering one's trademark with a trademark registry in Nigeria. Also, although a franchisor might still be able to enforce his own protected trademark rights under the common law thought of passing off, that is also recognized under Section 3 of the Trademark Act. But it's still advisable to register same to enjoy a broad protection of the trademark or the brand name or the brand logos. I also stated here that it's imperative that the franchise agreement is, yes, explicit on the use and limits of the franchise license. So when creating a franchise license, it should not be ambiguous. It should be explicit to the extent of which the franchisee can make use of the name and the logo, the goodwill of the franchise. The next one is copyright. Copyright is a universal right, and the creator of a copyright has the right upon expression and once it is shown that there is originality in the work. So, although a franchisor might not need to register its copyright, but also it's very, very advisable that in a franchise agreement that a franchisor states or ensures that there is explicit agreement on who will own a work that is created through the use of the franchise. It has to be stated. Otherwise, the creator of the work is deemed the owner of the copyright. And also, I found out during my research from an article that the NSCC has created a data bank of authors and their work. So it's also be good or advisable for a franchisor to take advantage of this by registering their works, their literary works with the NSCC. This would be useful when there's a dispute of copyright ownership of the work. The next one is patents. It's just similar to the trademark under the Patent Act. It's territorial too. So that means there is a need to register inventions that a franchisor might have, or that will be passed along to a franchisee through the franchise agreement to ensure protection of same in Nigeria. So a franchisor who desires to have protection of his patents that will be vetted by franchisees, maybe through the use of his franchise, or that will be passed along to the franchisee to ensure that such is registered. And also, it's advisable that also the franchisor should ensure that the franchise agreement explicitly states who will own an invention that is created through the use of his franchise during the currency or during the tenure of the franchise agreement. So that perhaps if a franchisee creates an invention, through using the knowledge or using the franchise, they might go ahead to register same and to enjoy the protection of the patent to the exclusion of anybody, including the franchisor. So it's advisable that this is also explicitly stated in the franchise agreement. The next one is trade secrets. Yeah, trade secrets, actually, now there is no legislation, unlike the trademark that has a legislation, the Trademark Act, the patent that has a legislation, Patent and Design Act, copyright that has a legislation, the Copyright Act that governs those IP rights. For trademark secrets in Nigeria, we don't have a specific trade secret legislation, just like the franchise itself. And we found out that trade secrets are very vital. In fact, it's found out that in fact they underpin a business continuous value. We can ask Coca-Cola. That's why today nobody knows how Coca-Cola is made, and nobody knows the secret of how Coca-Cola is made. Like someone said that, I don't know, I can't remember if it was on a platform here or somewhere else. I heard that someone said if people know, or if once people know the secret of Coca-Cola, they might not be able to make the sales that they are making today. So it's very, very critical that trade secrets is very, very vital. Unfortunately, without specific legislation that governs trade secrets in Nigeria. So there is this high risk of unauthorized usage of the trade secret of a franchisor by a franchisee. So the question is, how can a franchisor protect his trade secret? Well, before I state how a franchisor can protect his trade secret, I came across a case, Motorola against Itera in the 2020 case. I think it was it happened in one of the states in the US. Motorola were alleged that Itera, a rival company of Motorola, a Chinese rival company, actually stole their trade secrets when it hired 3 of its engineers from its Malaysia office. They further alleged that this Itera now developed, they used this trade secret to develop state-of-the-art products, which they sold and which they made a good amount of money from. Now, but what the saving grace of Motorola was that there was the courts relied on the acts, I think the Defense Trade Secrets Acts of the US. With that, the court was able to Motorola were able to get damages for the usage of their trade secrets. Now, let's imagine that's happened in Nigeria, of which there is no legislation that governs the trade secrets. What would be the fates of the franchisor actually? So, but the way, there are ways through which a franchisor can protect his trade secrets. Now, you can do that using a non-disclosure agreement or a confidentiality agreement, of which it will state the limits of the use of the trade secret by the franchisee, and also ensure that the franchisee, before using his secrets, you must also obtain his consent. So a franchisor should ensure that he enters into a non-disclosure agreement with the franchisee to protect his trade secret. Now, for me, I also state that, I also believe that a franchise agreement can also have a confidentiality clause. It might not be it might not be necessary to actually have a different non-disclosure agreement. The franchise agreement could have embedded in it a confidentiality clause restricting the unauthorized usage of a franchisor's trade secrets. So that's the end of my presentation. Thank you.
Thank you very much, Daniel, for this presentation. It's really detailed and I think it's really good. Before the mentors comment, I would like Sewese to finish her presentation so that you'll just comment on the franchising and AI together. Hi, Sewese.
Thank you, Ma. Sorry about that. I had issues with my connection.
Okay, it's fine.
Okay, so
Please continue.
Some fundamental questions. Okay, I was talking about some fundamental questions that are discussed on whether AI can inventions under IP laws. And I made a reason, for instance, under ownership. So the question was, can a human being, or should a human an inventor or the owner of a created work? Then another question would be, how can IP right holders be protected such that their works are not undervalued or seen as substandard to AI creations? So I also mentioned that in terms of infringement or criminal liability, who should be held liable for an infringement by the AI system? And then in terms of incentives, do AI inventions and creations need IP incentives? And then with regards to the existing laws and existing frameworks, does the advent of AI require any change to existing frameworks? So I've tried, in conclusion, to profile solutions the way I go. So with regards to whether should be changed, the existing should either be amended or specific laws enacted for AI inventions. So these laws would clearly state in terms of punishment for offenses committed by AI systems, and then also hold them liable where there's criminal liability or infringement of rights. Then consequently, with regards to whether AI creations can be incentivized, I also stated that AI creations can also be incentivized and adequate standards have to be set to ensure that human creations are not devalued in comparison to AI inventions. Should be named an inventor or owner. Also share the view that okay, let me go over that again. So I share the view that the autonomy of AI can diminish the worth of human thinking and invention. So that means that when it gets to that point where AI is independent, AI creations are totally in such that they can be a few rights, then it will sort of diminish the worth of human thinking, to sort of diminish human invention. So that's where I mentioned the issue of human works not being undervalued or seen as substandard to AI creations. So what's the way forward here? The way forward would be to adapt a more collaborative form of rights protections. And then also with regards to, sorry about that. Okay, so the way forward would be to adopt a more collaborative form of rights protection, and then putting into consideration the human element that is essential in managing the rights and obligations. And then alternatively, like it has been done in some cases, ownership of such work can be attributed solely to the programmer, that's the creator of the program. Thank you.
Thank you very much, AOSA, for the presentation. Um, so I would just take it now straight to the mentors to comment on Daniel's work, which is franchise, and Services work, which is AI. Let's call on Mr. Folarin to start the comments since he joined us a bit late. Hello, sir.
Oh, hello, can you hear me?
Yes, sir, we can hear you.
Hi, good
Thank you for
evening,
joining us.
Yana.
Good evening, sir.
Yes, sorry, I got the link a little late. I hope you permit me to leave my video off.
Okay, sir, that's fine.
That's okay, okay. So, yeah, great stuff. I listened to Daniel and Services presentations. Very interesting. I like the fact that Services is talking about AI and its benefits um, to IP lawyers. One of the she mentioned, I like that she took the conversation about artificial intelligence from its historical origin. There are many people. I think, for example, that the name artificial intelligence is an oxymoron. Can intelligence be artificial? If intelligence is intelligence, then it's original. You understand? So it's kind of, but the idea is it refers to um, the possibility that a non-human or a non-natural entity can have thoughts of its own, and has agency, And I think there are several issues that affect intellectual property when you're talking about AI. There are so many issues. Marx is an ICT person, so and Miss Nwokocha is she's a guru in that space. But issues about agency, about ownership, these are questions that what should be called like the moral and ethical questions surrounding AI. It's like Frankenstein's monster. Frankenstein created a monster. Dr. Frankenstein created a monster, and the monster came to life. Who was responsible, or who would be held responsible for the acts of the monster when the monster went on rampage and killed people? The question was, could the monster be tried? Does the monster have sufficient agency to be tried or to be treated as a distinct person, separate from Dr. Frankenstein? So I think these are some of the questions that we'll have to ask ourselves and answer in the next couple of years, because AI is a thing now. So I like the conversation also around how lawyers can benefit from AI. Last week, I like the trend. Last week we talked about how lawyers can benefit from blockchain, and then we talked about smart contracts, about things that. So now we're talking about how lawyers can benefit from AI. I noticed a trend in Nigeria. There are these chatbots. Chatbots are a series of scripts that give you a predetermined answer, and we call it AI. I think Law Pavilion has some. Everybody has one. The banks all have one. It's not AI because these are pre-programmed, responses the program cannot on its own, generate a thought. But at least as we walk towards that point, I think there are many ways in which in Nigeria, lawyers and even non-lawyers can benefit from, the impact of this technology. It will be good to see a little more. It would be nice to see the possibility of some kind of cross-fertilization, or let's see how if in preparing the presentation we can look at how African culture, kind of can be brought into the mix. That way it makes it easier for us to relate to. Think Wakanda, even though we know Wakanda does not exist, but we should think, Wakanda in that sense. As they will say, and then Daniel, good stuff. Franchise, the franchise business model of franchising, is a thing that that I think it's something that we're going to see more in Africa, going into the AFCFTA, and that's a concept that we also should get a very good grasp on. But I have a question, and I'm not sure. Daniel looked at though there's not so much data out there, the numbers, what's the franchising model? Does it work? Does it help an economy that is, into the World Bank categorization? Who does it help? What types of economies does the franchising model help? And under what conditions does it help those countries? And I think that's one of the reasons why we have a NOTAP as the National Office for Technology Acquisition and Promotion. NOTAP exists in theory, to ensure that that when Nigerian businesses enter into franchise agreements with third parties, that the agreements are not one-sided against the interests of Nigeria. I'm not sure I caught the NOTAP angle, in your presentation. I'm not sure I heard that. But it's very important because every franchise agreement is treated as a technology transfer agreement, and where it incorporates a trademark, assignment clause or a trademark license clause or a patent license or even a trade secret license, if there's any such thing as, if that's possible. If you license a trade secret, is it a trade secret anymore? But it treats all the licenses as some kind of technology transfer, and they have to go through a vetting process to ensure that it's favorable, and it doesn't that the Nigerian side is not tripped up. Now, how successful they have been in that venture is a totally different conversation. How the vast number of transactions that take place in cyberspace today. I have a number of clients who run drop shipping businesses, and you're running a drop shipping business with a warehouse or a manufacturer in China who manufactures, products that you slap your brand on, and so on and so forth. Does NOTAP doesn't get to see those agreements, and where as you're saying, there's a franchise arrangement involved. NOTAP will never even see the money because we have payment systems now that bypass the structure that the CBN would have used to trap the monies that haven't, for contracts that haven't gone through through NOTAP. So I'm not making a call for over-regulation. I'm just saying that these are issues that one will need to look at. We looked at the IP aspect, which is very fantastic. It will be good to look a little bit at what the numbers say in terms of the monetary aspects of of the impact of a franchise agreement. One person that I hold up, as well, maybe not the gold standard, but as an icon of the franchise model is Ray Kroc. Ray Kroc is famously known for his ownership of the McDonald's franchise, the McDonald's brand. Ray Kroc understood, the model, and he used it maximally to the point that he did not just build a fast food business. He also built a very strong real estate business, at the same time. So it's good to look at the numbers to see, okay, what's the value, where does in that value chain. Great present.
Thank you. Thank you very much, Mr. Folarin. Thank you for your wise comments and very practical comments too, both on AI and on the franchising topic. So let's call on Mr. Marx to also comment.
Hello?
Yes, sir.
I think my internet played a trick on me, but
okay.
Very much, Daniel. Thanks, Juliana.
Thank you, sir. Thank you very much, sir. Okay, so over to Mr. Marx.
Okay, thank you, Juliana, and thank you, Silvese and Daniel, for two really stimulating presentations on two very exciting aspects of IP, franchising, and of course, the new kid on the block, artificial intelligence, and how it intersects with franchising. And of course, also acknowledge my Oga at the top, Mr. Aluko, for his very incisive comments. In fact, I don't have much to add. One of the, I'll start with franchising. Mr. Folarin has actually the first thought I had, which is I think Daniel did not consider properly the NOTAP angle to it. Even though I agree with your basic premise, which is that there's no sui generis law on franchising in Nigeria, but I think the impact of NOTAP Act on franchising business model is very important to always speak out, even though it's not specifically focused on franchising. Then another law in a business model, I think the IP angle to it, the Federal Competition, Federal Consumer Protection and Competition Law, that's the FCCPC Act as well. There are a few things it says that I believe have a huge impact on franchising as a business model and how the franchising agreement should be structured. But what is most important about franchising is that franchising is one business model that relies wholly, completely, and totally on IP. Without IP and the protection that IP offers, franchising as a business model would not be viable. It wouldn't even exist at all, because the first thing it does that is because IP has helped you to ring-fence your assets. That is how you are able to replicate that asset in a jurisdiction by allowing someone else exploit that asset under the franchising agreement. So IP is crucial and absolutely important to franchising. Another important aspect is that in countries where, for instance, the US, if you do a little bit more research, you find out even when they have specific laws on franchising, a lot of times those laws are actually focused typically on more of a consumer protection angle, just to be sure that the franchisees are not taking advantage of. Because in the franchise relationship, you're always having, the unequal bargaining power in the franchise. So it's always a huge, likely multinational with a lot of experience, muscle, financial and legal powerhouse behind it. While the franchisees typically sometimes maybe just a retiree who wants to invest his money rather than be an entrepreneur and start a business from scratch, just get a business model that already works and leverage on that. So typically, a lot of those laws tend to aim towards protecting the franchisee, who is typically the underdog in that relationship. So just also a good teaser as well. I want to ask, apart from Julian, apart from Maggie, is there another foreigner in this class? A non-Nigerian, sorry, in this class, apart from Maggie. Okay, Brandon. Yeah, so I'd like to ask Okay, I'd like to ask, the non-Nigerians also, look at your laws in your country. Let's find out, do you have the equivalent of the Nigerian Office of Technology Acquisition and Promotion, which essentially is the government office that vets, Mr. Aluko has spoken about extensively, that vets agreements that have technology transfer components. I would like to know your own jurisdictions, what of things, and then we also want to know your jurisdictions. Do you have a competition law, and does it have any impact on the franchising as a business model? Then I'll wrap up quickly on the artificial intelligence. Like I said, as a kid on the block, creating a lot of forcing us to rethink IP as a whole. And one of the important aspects, really, of the intersection between intellectual property and artificial intelligence, really, beyond regulating the rights that are created, the policy question: should IP law be used to encourage creation, autonomous creation of IP works? Because one of the things that IP law does, or IP policy does, is that when IP protects a particular range of activities, it encourages people to invest in those activities. So the question is that should the government, using IP policy, encourage creation of IP works by artificial intelligence systems, by creating special protections, or should it discourage that by not giving special protections to artificial intelligence, IP created by artificial intelligence systems? So this is a question that we need to ask and resolve at the policy level before we now talk of the specifics of what the law and the protection that should be granted. So it's an interesting area. We see how it evolves. And particularly to mention that I'm rooting for Sese. She contacted me and I recommended her for this course. So I'm happy to hear that this afternoon. I encourage her to keep up with the course. So thank you, and back to you, Juliana.
Thank you very much, Mr. Marx, and thank you for the recommendation. I think you also recommended this to Daniel too. So thank you so much for bringing in young people here to learn. So would welcome Mrs. Uche to also give her comments.
Thank you.
Thank you.
I've really learned so much from the two speakers, because oftentimes you think we keep learning. So I've learned some aspects of IP law practice today. So I think it's kudos to them. So I like to comment on, I really like the analogy that put up by Mr. Aluko, the monster analogy. I'm commenting on AI now. So AI is just a machine, and some people had tried to link it as patent. Patent will give an inventor protection over the invention that they developed. Then for the machine, so who do you really, you cannot, AI cannot really compete, and it cannot be seen as, it cannot be accorded protection, because who do you give protection? Do you give it to the machine? Do you give it to the operator? Do you give it to the person that really developed it, or the person who has at the back end is operating it? So it's really opened the floodgates of cases and confusion. So, and I think at best, because the machine needs supervision, you can't just give the machine protection and it will work on its own. Supervision is required. So I think that at best, AI is just an algorithm. So a supervised one for that matter, because it cannot operate on its own. And I remember that the presenter had said, oh, part of the recommendation was that maybe the laws should be amended to include protection for AI. But then you draft laws that are enforceable. So how do you really give? So perhaps over time, AI will take a mode that will really require protection. But now there are a lot of heated agreements going on world over. People are confused. But one thing is sure, you cannot be granted protection like you do patents. So let leave that and go on to the IP protection and franchising. Yes, franchising, we don't have a franchising regime in Nigeria. The closest we have is licensing with the trademark registry or licensing with NOTAP. But whilst licensing is distinguished from franchising, with licensing, the brand owner or the proprietor gives you right to use their intellectual property. But with franchising, you actually use the business name. So it gives you the name, not just the trademark. You can use the name if it's McDonald's or Kentucky Fried Chicken. You really use the actual brand, not just the trademark. You also use the trade names. But the problem arises when at the end of the agreement, term of agreement, getting the name back from the franchisee becomes a problem. Because you remember the franchisor is probably coming from overseas. He's not known, for instance, within the Nigerian jurisdiction. The reason he needed a local partner was because somebody who is on ground knows how the business is. For instance, the franchise agreement that was signed between Mr. Biggs, UAC, that owns Mr. Biggs, and Inscore, which is a company from Mauritius that owns Chicken Inn, Pizza Inn. There was a time they had the Chicken Inn, Pizza Inn, Creamy Inn, and they had it in, they used the model, they had it, they called it On the Run. And it's on every mobile filling station, so that if you're buying, so it's called co-branding, so that whilst you were waiting or queuing up to buy your fuel, you can go in and buy chicken or pizza from this franchise thing that they had with USC. They needed Mr. Biggs to be able to do that because already you had Mr. Biggs in some of these stations. But that gave Mr. Biggs a kind of visibility because in the past, Mr. Biggs is probably a low key. If a guy wants to take you out and takes you to Mr. Biggs, I mean, what's that? But after they had this agreement with the Creamy Inn, I think that's kind of upped the game for UAC's Mr. Biggs. Everything changed. But then that problem then arose when at the end of the 10-year term, they started having problems. You will always have problems with business partners. That's why it's always good to sign what is called the master franchise agreement. You need to. And I know that Mark mentioned NOTAP, how you needed to, because NOTAP will have a say. NOTAP will regulate those agreements to ensure that the conditions are fair to both parties, especially to Nigerian, because in the area of technical service agreements or transfer of technology, you're actually transferring a technology that is not in Nigeria. So if NOTAP looks and says that this is what we have the scale for in Nigeria, they will not approve that agreement because you need to go through NOTAP. There are a lot of hurdles. You look at that, the legal framework, and then you look at all the financials because NOTAP will now give you a certain percentage. Mr. Aluko mentioned that who does it help? Does it help a nation? Yes, it does. It helps the economy. And that's why NOTAP is there, because NOTAP will look at and give them milestones. So if in the case of USC and On the Run and the Chicken Inn and Mr. Biggs, they were opening stores. So NOTAP will give a condition, how many stores you open within a certain period, because that agreement was for 10 years. So that if after 2 years, they see that you've opened stores in Mushi, not only in Lagos, they say, oh, you're serious, then they can increase a percentage of the money you take out of the country. And that's where they involve CBN, because CBN, without the approval from NOTAP, CBN will not allow them to take money to their national countries. Because if you're bringing an investment into Nigeria, you want to do business and take your profit back to your country. But that's where NOTAP comes. And it was really like a tough one because NOTAP is looking at every detail to make sure that the Nigerian government is protected, and also that people do not use it as a means of siphoning money, because you would come and sign an agreement with somebody and then they give you approval that with CBN, and then you take out millions of dollars. No, you don't do that. So there are milestones. NOTAP will look at every milestone and then look at the royalty that the franchisee is paying to the franchisor for allowing them to use both their business name and their trademark. Let me see if I've covered all the points. But it's very important also to know that the term of agreement, usually for a franchise agreement, is usually like 5 years, because they want to, that's why NOTAP will look and see that they don't give you a blanket approval. So they look at, if you have done well after 5 years, they can renew. The exception, however, is with respect to big ticket transactions like hotel. Because if, for instance, when Hilton was trying to do with the Hilton Abuja, before you even finish building and then having the supplies and having everything, the managers and getting your staff, 5 years has expired. So for franchise agreement like that, they allow long-term, maybe 10 years, but it's done on a case by case. You need to go to NOTAP, engage, they query it, you go back and do what they want you to do, then you come back and they just touch it off and on until finally you're given the go ahead to proceed. And we talked about that you needed to register your trademark because it's key, or not really the trademark, the intellectual property now, because it covers both patent, copyright, and what have you, and designs. And the presenter has said, oh, you might just be okay with passing off. No, you can't be okay with passing off because it's a long journey to legal suits, because you don't want to go to court and with our system where you stay in court for 10 years, start arguing whether who has what. No, you need to have registration. And registration, once you have registration, you don't need to prove it in court. You just say that I have my certificate and this person is infringing on my rights. So it's easier to prove that in court than passing off. Then of course you need to do IP due diligence, because you want to know what is registered and when and how and where. Because your IP is attached to your business. If it's not registered, your partners won't even want to engage, because, for instance, any product that has patent is the product that you attach the patent to, or even goes with trademark as well. The product is nothing until they attach the intellectual property or trademark or patent or one. So without it, they will not engage, because who will buy if they don't see that you built your brand? So registration is key, and you need to do that due diligence. Look at everything. Look at your partners. Know if they are shady, because you don't want to engage with business owners that will take the money and disappear. So those are all the things you look at, and then have a lawyer to draft the agreement, cross all the T's and dot the I's, because that is what you will go back to. It's like the constitution of the master franchise agreement is the constitution for that that partnership, so that you will always. I remember when the company had issues with UAC, you needed to look at that agreement, and that will help. Go to the board, and everybody will look at the agreement. Will speak for itself. So and then you put a percentage of royalty payment, and then the trade secret. Of course, we have talked about it over and over again, except to say that it ceases to be secret when it's no longer a secret. So it's very important. The key thing about trade secret, it must be maintained as a secret. You mustn't let it out, because if it goes out there, then the people that are paying you money for the trade secret, it's a breach of agreement, because they cannot make money, because the secret source has been known by somebody else. So that restaurant downstairs from your building, where everybody goes to buy kidney pie or meat pie or have a good chicken curry, if they now find out that another person has opened down the road and has the same secret sauce, then it ceases to be trade secret. So I guess that's it. And then apart from helping the country, if we are talking about benefits, it also helps the businesses and the nation. Apart from the economy, it creates job for the people, because if they come here and open business, there will be Nigerian staff that they will employ. And then if people love to eat McDonald's or Kentucky Fried Chicken in England, and then you bring it to Nigeria, it's like development. You're really making our lives better, because people can go out and eat the same thing. They don't have to go to London to enjoy McDonald's or Kentucky Fried Chicken. So those are few benefits. And please, I like to beg for permission to, because I have another meeting, if I could sign off in the next 10 minutes, please.
Okay, ma, thank you very much, ma. You've actually done a lot for us so far. Okay, so let's quickly hear from Tola. Tola, are you ready to present now? How is your network?
Yeah, it's okay now. You can hear me?
Yes, we can hear you, although it's still a bit shaky.
Okay, so my name is Adetola Naomi. I'm from Nigeria. The article today is the early stage of a startup and its IP, intellectual property. I wrote this article because I wanted early stage startup.
Tola, your network is not good at all today. Maybe you do your presentation next week. Probably it might be in a different location. Can you hear me, Tola? While we're waiting for her to get the message, Brandon.
Yes, I'm back. Can you hear me?
Okay. Yes.
Good. Okay. So as I was saying, I started with saying that a technology startup's intellectual property is crucial to its success, and I went on to highlight some of the most common precautions that should be taken by startups, especially for early stage startups, in relating to their intellectual property. The first one is to assign all IP rights to the startup. I believe a founder's technology, or should I say invention, should the IP of a founder should be assigned to the company. I mean, all founders should pass all their IP to the company. It does not mean that this is my innovation, and there's a difference between having the owner having the intellectual property and the company itself having the intellectual property rights of an invention. So all founders should pass their IP to the company. Also, employees should also sign an assignment clause that will transfer the employee's work to the employer. It's very important. Then the second one is to register a suitable company name. Before registering a company name, founders should ensure that the company name has not been used by another person and is appropriate for commercial use, and it is in line with their brand's mission and values. Now, for the third one, I said registration of any other IP. It's very important that any other IP of a startup should be registered. I mean, your trademark, your design, or any other invention that you have. Then also, the next one should be to take care while using open source. Everyone knows open source software is very, very free and can speed up software development. But in a case that the copyright is violated, it may not be allowed. It may not be allowed while building your startup. So you should take care while using open source. And I think that's all. That's all for this.
Thank you very much, Adetola.
Presentation. I want to rush through it so that, yeah.
Thank Thank you
That's
for
all. Thank
coming through,
you.
even with the internet issues. So since we still have Mrs. Uche with us, please can you comment first before you leave?
So thank you so much. Nice presentation. I mean, these are the nice crop of people, really. And I wish we had this when we were doing IP or when we were in the university. So it's really very challenging. And then I'm really learning so much. So with startups, we do know that when you're starting a business, because you're not known, you tend to allow everything to go. So during negotiation, you just relax, and then if you're engaging in a business with another business partner, because you're a startup, because there's what is called in intellectual property senior mark and the junior mark. So you can imagine a less known company in Nigeria negotiating with Coca-Cola over bottling or over sales. So oftentimes you find out that you're not in a better position to negotiate. So that's what really happens with startups. So anything goes because they're coming into the markets and they are not known. So they allow a lot of things to slip, not realizing that it's just a question of time. They become well known. Then you look back, all of those things that they did not do right, like the presenter rightly said, will not come back to hunt them. So it's very, very important that they talk to professionals, talk to lawyers. Just don't be in a hurry to go out there. It's good, but you need to put your business models and everything in order and ensure that your business is protected. That's the key, so that nobody takes your intellectual property. I remember in the past, I had to advise a business, a startup company who was like reviewing the agreement. He agreed so much to the other party. So I'm like wondering, said that he's in a hurry, they want to get going. You don't do things like that. We must resist the temptation of signing too quickly. You need to look at it to make sure that the agreement is balanced and so that you're protected in future. And they shouldn't really beat themselves down, because if you come up with an idea, that means there's an opening. That idea is not there already. So you should really secure it and to be able to reap from that creation. I guess that is my 2 cents. I'll leave it to my 2 learned colleagues to take off from here. I really hate and I regret that I had to go. I have another meeting, but I look forward to joining you again in future. Thank you so much and have a great day. Bye.
Thank you very much. Bye, Ma. Thank you. Okay, so let's call on Mr. Marx to also give his comment.
Okay, thank you, Juliana.
Thank you, sir.
That was another excellent presentation. Quite an touch on the angle, one very important in your development. Because what happens is that under the license terms of free and open source software, once you use that software in designing a proprietary software, so proprietary software, are those software that you develop to use for purpose of commercialization. So if you use free and open source software in developing your key proprietary software, it means that other people are entitled to use the developments you have done. So that means you lose that exclusivity to use your proprietary software alone, because with free and open source software, the condition on which you use it or the license is that you must allow other people also to use the software just the way you have also used it, and every improvement you make to it become also open source and others can. So it's important you highlighted that component. Then other IP for startups actually is a key cornerstone of the private equity market. So most private equity firms, when they come to fund your business, even if your startup fails, they're going to get some money out of that private equity deal. Is the fact that your company has developed unique IP that they'll be able to license or sell, assuming your business fails. Their hope is that worst case, like the security, there are a lot of small startups bought by Google, for instance. Sometimes Google buys these startups not because it needs the startup necessarily. Sometimes it's because it needs the IP portfolio they own to help it prosecute a particular patent war. So, for instance, when we had the famous patent war between Samsung and Apple, they bought a lot of startups just because they needed the patents that those startups had to help them, increase their portfolio of IP rights to be able to fight that battle. Sometimes big companies will buy you not because they need you, but because they need freedom to operate. So I'll give that assignment to Adetola to read up on freedom to operate. So freedom to operate, and to everyone actually to read up on freedom to operate. Freedom to operate simply means, the right to be able to exploit your IP without infringing on others' IP. So you have to check to be sure people that have not already registered IP before your own. So sometimes people buy up startups just because their software or patent portfolio to be able to have that freedom to operate in the market. So it's a very important topic for startups to understand, because with that, startups already are on the road to success, because once they have that IP portfolio, somehow they have some measure of guarantee that they can be successful as a startup. So thank you once more, Adetola, for that wonderful presentation, and Juliana.
Thank you. Thank you very much, sir, for the comments. So let's call on Paul to give his presentation. Hello, Paul. Okay.
Hello, good afternoon, everyone.
Hi.
I hope you can hear me.
Yes.
Hello.
Yes, I can hear you.
Am I audible?
Yes, you are.
Okay. Thank you very much. My name is Paul Atamewan, and my presentation today would be on the ways and the need for the protection of an artist's name and product. The ways and the need for the protection of an artist's name and product. I particularly wanted to write this article because in most situations, artists, especially upcoming artists, always see the need to protect their intellectual property. And the reason I called it a product is because the work of an artist is a literal work, and their works are goods and service. So I call it a product. It's a product of their work. And so most of the times they see the need to protect their product, but they do not really see the need to protect their names, in the sense that and this has also proved to be a very common mistake among artists. Even already made artists, there are a lot of scenarios where I can show you that already made artists made these mistakes in the past. And so today I'll be talking about the reasons, the ways and the needs for the protection of the artist names and their product. First of all, I'll be talking about the concept of intellectual property, which is which I'm very sure we are very conversant, which I'm very sure we're all very conversant with. I'm sorry. Now, intellectual property refers to ownership and possession in creation of the mind, such as your inventions, your literary and artistic work, designs and symbols, names and images used in commerce. Now, there are 4 categories of intellectual property protection. Basically, we have the trade secrets, we have the copyright, we have the patent, and we have the trademark. So those are the ways in which a person can protect his or her intellectual property. Now, the need for an artist to protect their intellectual property is to own the title to their name. a lot of people do not believe they need to protect their own name, or they need to protect their own interest in their name because they created the name and it's a name that is known to be assigned to them and them alone. And so they do not feel there is a need to protect their name. Now, the need for an artist to protect their names, their royalties and every other benefits associated with their name as an artist. Now, in signing an artist agreement or any other agreement with a record label or an independent contract or whatever it is you're signing, an artist should look out to protect their names and their products for the duration of the agreement and beyond. An artist should always look out for clauses in the agreement, clauses in the document, clauses in the draft to see to protect their intellectual properties, so they do not make mistakes, so they do not it is possible, it is very possible for an artist to tell their names, even if they don't know this. A lot of people do not even know this. After an artist might have been using his or her name for a period of time, and then when he signs an agreement, maybe with a record label or an independent contract, he might actually be selling off his name and his products. It is very possible. Okay. The need. These are the needs for an artist to protect their intellectual property, to protect your name, to protect your royalties, to protect your benefits, the benefits attached to your name, and so forth. So now, to protect, another reason for an artist to protect his name is to protect others from the use of their name, including your merchandise, which is your product, your literary work. You should register your trademark. You should register it as a trademark. An artist, to protect the intellectual property, there are different ways to protect your intellectual property, but protecting your intellectual property as an artist, your name as an intellectual property, is the right form to do this is by protecting your trademark, protecting it as a trademark, protecting your name as a trademark. Now, I know there are situations where a name can become generic. Like, for example, we have people like Beyonce, Rihanna. We have people like Whiskey, Burna Boy. We have people like very popular. These people do not actually need to trademark their name or protect them. It is generic. Nobody can own any right or title to their name, whether it is protected or not. There are situations like this. Now, we have seen the escapade between Wizkid and Wizkid. There was this story that was going on, I think, last 2 weeks or 3 weeks ago, where an artist, Wizkid, which sounds very similar to Wizkid, also was using the name to trade a cloned album of the original Wizkid, which is called Las Giddy Made. And he made sales on Amazon and Apple and so forth in order to make it. This was actually obviously a fraudulent attempt. Actually, still an allegation for now. It's obviously was a fraudulent attempt using an artist name, but I'm sure Wizkid would not have had the rights to protect that intellectual property, aside the fact that his name has already been generic, is already generic and already known by everyone to belong to him and only him. I'm sure Wizkid would not have the right to lay claims to that name. Aside the product now, he owns the product and made his own intellectual property to the product. I'm talking about his name now. Aside the product, I'm sure Wizkid would have not had the right to lay claim to that name if he had not trademarked it, or if it had not become a generic name as it is with Wizkid right now. So this, the Trademark Act, provides in section 3 to 8 the effects of registration and non-registration of trademark. Now, an artist's name is a corporate asset and a very tangible and has real tangible value. Protecting it is a very important business consideration because the name is an asset as it is. Now, in relating this to recent cases, we can see, I'm sure we've heard about Cynthia Morgan, the now Madrina, who signed a record label agreement, a contract for a record label, not knowing she was actually selling her name and her product. And now, after her exit in the Joel Okoye's record label, she no longer had the right to lay claim or hold the title to the name and the product within the duration of her contract and now beyond. We've seen people like Madrina, the Cynthia Morgan, now Madrina. We've also heard about people like Two-Face. Two-Face actually started up with Kenny's Music, and he started up as a Two-Face, and not knowing he was actually signing the contract. Now, there's something I want to point out, which I'm sure every lawyer should know and every learning lawyer. Now, the law looks at the form and not the intent. That is a very common phrase. The law looks at the form and not the intent. The law looks at the intent and not the form. It looks at the intent and not the form. No matter what, it looks at the intent and not the form. If a contract agreement is named record label agreement, or if it is named artist agreement, whatever it is named, the clauses in the contract is what matters. The clauses in the contract stating a particular thing is what matters. We all know that the heading of your agreement doesn't really hold water when it comes to reading the contents and the provisions of the agreement. A lease agreement, for example, now diverting, sorry about that, just to expatiate, a lease agreement can actually turn out to be a sale agreement. An agreement for something else can turn out to be something else as long as the content, the clauses in the agreement provides for such. And now, this is one of the reasons why a lot of artists have lost their names, signing agreements, not knowing the clauses contained in the agreement or the reasons for the clauses, or just reading the headings or looking at the form and not the intent of this agreement. In Cynthia Morgan's case, this was due to a failure to protect her name and her literary work. She assented to the artist contract agreement, transferring all her rights and title to a name and the works of to a record label. In the event of her exit to a former record label, Due Diligence record label, she forfeited all her intellectual property assets and her name. Now she doesn't have the right to bear this name on whatever platform, whether on social media, on stage, on her albums, or whatever she does. She doesn't have the right to hold or lay claim to these names. Once you sell out your agreements, once you sell out your name by signing agreements like this, the name no longer becomes yours after exit to the record label. Now, a few artists in Nigeria has also been a victim to this. We know of the recent Kiss Daniels escapade, in which he had to change his name from Kiss Daniel, K-I-S-S, to Kiss Daniel, K-I-Z, Daniel. We know of the Cynthia Morgan. We know of the P-Square. Now there is no P-Square and nobody can lay claim to the name P-Square. They were also signed to the Due Diligence record label. And now they are just Peter and Paul Okoye. Nobody can hold, aside the splitting of P-Square, if they had left the record label and went even together, they would still not be able to lay claim to that name because according to the contract they signed, the name becomes a property of the record label. Okay, there are a lot, numerous international national artists, but I'm just going to go on.
Hi, Paul, can you hear me, Paul?
Time. Now, however, there are measures to undertake to prevent such agreements,
Okay, I think he's having internet issues. Let's
from happening. So, number one, every artist said to frustrate the artist. And she was emphasizing on the need.
Hi, Paul. I think you're having internet issues. Okay, so Brandon, you can just continue the presentation. Start your presentation, then Mr. Marx and Mr. Folarin will comment on both presentations.
Hello, can you hear me?
Yes, we can hear you.
I'm trying to share my screen now.
Hello?
Yes, Paul, please can you quickly round up if you can hear me, Paul? Can you hear me, Paul?
Okay. I'm rounding up now. She was emphasizing on the need for lawyers and past mistakes and why she thinks every artist should get a lawyer. Now, number two, every clause in the employment agreement, independent contract agreement, do not transfer. Every artist should ensure that the clauses in the employment agreement and the independent contract agreement do not transfer ownership to their literary works and their names. Now, every agreement should be read and preferred before signing. Every agreement should be in writing and clearly spelled out. Amendments in the agreement should be made before signing the agreement clause that retains the artist's rights to the name.
Okay, Mr. Paul, are you done? Okay, yes, I think he's done. So, Brandon, please just go ahead and make your presentation so that the mentors can comment on the two presentations together.
Okay, I'm sharing my screen now.
Okay.
Can you guys see it?
Yes, we can.
Yes. I know I have a very short time to present, but before I begin, kindly let me begin by making a comment on what Maggie presented. She made a presentation about a startup in Kenya called Enda. Yeah, so I would like to point out that whatever she presented on real and relatable legal issues, because I did an internship at Enda Running, and I would really like to join her in doing a research on that subject. Having said that, I'd like to go straight into my presentation. As you can see,
and your country.
Yes, sorry for that. My name is Brandon Omondi. I'm joining from Kenya, Nairobi. My presentation today is on COVID-19 and IP rights and how we can mitigate the adverse effects of the pandemic. So, COVID-19 was declared as a global pandemic by the WHO due to the rate at which it had attacked many countries. So, in different countries, governments imposed certain measures in order to control the spread of the virus. So, as we have experienced everywhere around the world, these precautionary measures have posed different effects on diverse forms of intellectual property, like patents, copyrights, trademarks, and trade secrets. So, I'm going to discuss how the pandemic has affected these areas of intellectual property. So the first one is patents. Let me just begin by saying that when we talk about the effect of COVID-19 on patents rights, this is the main issue that arises. That is the interplay between the right to access the highest attainable standards of healthcare and the rights of patent holders. I know in many African countries, for example, Kenya and South Africa, the constitution provides that every person shall have the right to access the highest attainable standards of healthcare. Now, we are in a position where the public health is at stake due to the virus. In many countries like Malta, we have statutes that give ministers the powers to authorize the use, manufacturing, and invention and exploitation of an invention without the patent owner's authorization. Now, the COVID-19 pandemic has brought us into a position when patent holders now have to suffer because their innovations are being used even without the authorization. So this raises the larger problem of how we may balance the right to access the highest attainable standards of healthcare, because now things like ventilators, guys have been inventing different forms and ventilators and personal protective equipment, and the government gets to use them sometimes, even without the authorization. So that is one issue that has come up during the pandemic with regards to patents. Then secondly, we have trade secrets. So I'm sure in most parts of the world, we have lockdown restrictions where the movement of people to and from their workplaces has been restricted. In other words, now people are forced to work from home. Guys are forced to work remotely. So there are certain risk factors that are associated with working remotely, and I've listed them here. The first one is working remotely may involve taking commercially valuable information out of a secure environment into a less secure environment, because not everyone has the same level of, for example, firewall protection in the software that they have at home. Then secondly, another risk factor is using unsecured emails or computers to transmit valuable information belonging to companies with trade secrets. So you realize that this jeopardizes the whole security of such information. And finally, sometimes you may need to dispose documents. Not everyone has things like shredders at their homes. So they are forced to dispose these documents in ways that are not very secure. This also jeopardizes the integrity of some trade secrets. I don't know if I'm moving too fast, but I'm concerned about time. Yes?
It's good.
Okay, thank you. Then the other area is trademarks. And one area that has been of particular concern is the consumer goods industry. So since the pandemic struck, there has been a rise in cases of trademark infringement. So one example that I came across during my research was that trademark infringement was so rampant in the Philippines. It reached a point when the National Committee on IP Rights issued a warning against counterfeit products circulating in the market. And this has mainly been experienced in online shopping platforms. I know a few in Kenya where there's a lot of trading in counterfeit goods. I don't know if you guys have the same in Nigeria, but as you can see from this slide, that online shopping platforms have experienced the highest rates of passing off. So this can be attributable to one fact, that is, there are no adequate measures for flagging counterfeit goods. And for example, we have a system in Amazon called transparency, where not only the sellers but even the customers are able to flag counterfeit goods. Not so many online shopping platforms have this system. Another example, I don't know if this arose as a result of COVID, but I only use it because it arose during the period. And one of my learned colleagues had raised this example. There was a recent suit. I think it was Maggie who raised it. Nike versus Mischief, where there was a dispute about the propriety of the use of these certain shoes. So Nike are claiming that Mischief had used their product to make the certain shoes and to associate it with satanic activities. So given these two examples, we see that there are serious issues that have come into light during the COVID-19 with regards to infringement of trademarks. So another effect, and now this is winding up now. These are other effects that COVID has posed to intellectual property. We have the restrictions on movement and social and physical distancing requirements. So all these measures, the totality of these measures has been that it has been difficult to access courts because in countries like Kenya, for example, the physical filing and hearing of cases had been suspended for a while due to these social distancing guidelines. So this has made it difficult for people, especially litigants in IP issues. They cannot access courts and therefore they cannot be heard. And we also have online systems that have been put in place. But I have to observe that these systems are not very, there can be no expeditious determination of matters in this platform. Or if they can be, if the courts can try to hear and determine matters expeditious, they cannot do it with the same speed that matters are heard and determined in physical hearings. Another effect, another adverse effect of COVID on IP rights. We have certain IP rights are created by virtue of contracts. Now, the pandemic has led to the violation of IP rights through breaches of these contracts. For example, we have people that have become bankrupt during the pandemic. So, for example, when it happens, unfortunately, where a licensee or a franchisee, as one of my learned colleagues made a very eloquent presentation on franchising. So when it happens, unfortunately, that a licensee or a franchisee goes bankrupt and they cannot perform their end of the bargain, now that becomes an issue. Another example, and this happened over the weekend. I'm not sure if it was over the weekend or it was just a few days ago, when there was an attempt to create something called the European Super League. And this league would have adverse effects on the contracts between football clubs like Chelsea, Arsenal, Man United, and the UEFA and the Premier League. So this is just one of the examples, and one of the reasons that was given for trying to come up with this European Super League was the financial difficulty. The financial difficulties that these big clubs have faced over time. And now, I think COVID was just the last straw that broke the camel's back. And that's why this issue came out at such an unprecedented time. So given that analysis, we can see that it is arguable that COVID-19 may be construed as a force majeure. And I'll move on to the next part of my presentation, which is mitigating the adverse effects of COVID-19 on IP rights. So I had mentioned that there has been a difficulty in accessing courts by litigants, and this has derailed the process in which litigants whose IP rights have been violated can access courts. And ultimately, this deplorable state leads to, in most African countries as well, we have the right to access justice. So COVID has jeopardized this right as well. So in order to solve this problem, certain measures have to be taken in order to establish online or virtual hearings of matters in courts. For example, in Kenya, we have a system where cases are managed electronically. You can file cases without having to go to court, and these cases can be heard and determined virtually. Then that was the first part. Then the second remedy would be the one relating to counterfeit goods on online platforms, online shopping platforms. So the example I had mentioned earlier of the system called transparency that is used by Amazon to flag counterfeit goods. These are not automatic system, but Amazon also has that provision where sellers and even consumers can flag counterfeit goods. And one good thing about Amazon is that if you're a person trading in counterfeit goods and you are flagged down justifiably, you are banned from the platform and you cannot access the platform in any form whatsoever. So this report proposes generally that we need to adopt this system in most of, ideally we should adopt it in all online shopping platforms. And then finally, because some of these adverse effects have been faced and some of them have not yet been faced. And I think one thing that COVID has taught us is that you are never sure of the future. We may have known that in the past, but COVID, I think, has just rubbed it in. So one thing that parties to IP rights agreements need to do is to ensure that they have force majeure clauses in order to provide for unforeseeable predicaments that may make specific performance difficult. Having said that, I'd like to thank all of you for listening, because that is the end of my presentation. Thank you.
Thank you very much, Brandon, for your topic. So we'll be calling on Mr. Folarin to quickly comment on Paul's work and Brandon's work. Paul's work was on the protection of an artist's name and product, and then Brandon's work is on the effect of COVID-19 on IP. You're welcome.
Thank you.
Yes.
Thank you very much, Juliana. And well done, Paul and Brandon. Just very quickly, let me start with Brandon. Yes, I think that was an interesting presentation. It was a good read. COVID-19 has affected every aspect of our life. Or let me reframe that. The global reaction to COVID-19 has affected every aspect of our lives. And that stems from the fact that most countries in the world adopted a shutdown method as opposed to, other types of possible responses. What that has done, I think, and I think you highlighted that, is it has acted as a force majeure. I remember almost the first 1 or 2 months of the lockdown, almost every legal article in the legal sphere, touched on some kind of force majeure, the effects of force majeure, application of force majeure, and so on and so forth. So I do think that, in that sense, COVID-19 has affected many obligations of parties under, who have some kind of IP exposure or the other, or exposure in relation to IP. I'm not sure I was listening, but I think there should be, I think you could, or you should pay more attention to the COVID vaccines. I hear an echo. I'm not sure if it's from my end, but I think you could pay more attention to the COVID vaccines and to the conversation around, the use of the patent system, to restrict, what you may call the yeah, it's also a moral issue. So the morality of the granting of patents, to COVID COVID vaccines. I think that's it's still an ongoing conversation, but the general attitude of most supranational organizations, I think, is to suspend. I think there have been calls in Africa, especially, for the suspension of the operation of patent rights, the exclusivity or the monopolistic components of patent rights when it comes to the COVID vaccine. So I think that's a huge conversation. In Unijust, just to poke fun at Unijust said they developed green tea as a solution. So there's also, I think, to some degree, a conversation around traditional knowledge and traditional systems, traditional methods, and whether, given the similarity of the SARS-CoV virus to the malaria, to malaria and other strains, given the similarities between the symptoms, and so on, there's that conversation around, or there should be a conversation around whether we can use traditional remedies. For example, in Yoruba land, there's an agbo that is made for people who are suffering from malaria, and in almost 24 hours, that agbo means herbs, so it's like a concoction. In like 24 hours, all the symptoms of malaria are gone. There's another agbo that is used for children. So the idea is we have traditional solutions to similar, similar, and so I think there should be a conversation around exploring the options of, either subjecting these traditional methods to, or traditional solutions to some kind of testing, or to some kind of lab experimentation and so on. Unijust, when pressed, came out to say, that they hadn't done extensive testing and so on and so forth. But I think that there is a conversation to be had on that ground. So I would say well done, Brandon. But yeah, well done. With regards to the conversation around artist names, I have an interest in artists' names. I think that's Daniel, isn't it?
Paul, that's Paul.
Oh, sorry, Paul. Well, Daniel has gone already. I'm sorry about that. Paul, I'm in a very interesting place, as Juliana would testify. So I think Paul's heart is in the right place, but I think there might be a slight disconnect between perhaps what I think Paul's article displays what you call the discrepancy between the is and the ought proposition. So we know what is and we know what ought to be. And in an ideal world, all creators would own their creations. But the world isn't ideal. There are so many other considerations to be had, and there are contractual issues at play. And so sometimes, and I can name off the top of my head about 10 different instances where the artist's name came from the label. I can give you, in Nigeria, for example, I know like 3 different instances of where even the artist's voice, not like the physical voice, but I mean the inflections, the tone, and the everything that was the components that made that artist unique, came from someone else, came from one of the producers and co-writers. So in that situation, the question is who owns the persona? And I think we should distinguish between, so that's a conversation on the one hand. I also think we should be able to distinguish between the persona and the name. So that might throw some clarity. I don't like jumping on bandwagons when people are saying, oh, this person is that or whatever. So for someone like Cynthia Morgan, for example, her real name is Cynthia something Morgan, and I don't know how trademark rights can be used to stop somebody from using his or her real name. Many people usually go default to their real names. So I don't think, if you ask me, if I were to give a legal opinion as to whether she should have changed her name, now Madrina is a pseudonym, and to use that name, she would have to either own the rights or own the license or whatever. But she doesn't need a license to use her real name, even if it's on stage, in my opinion, in my very humble opinion. And you can look at Section 9 A, I think, of the Trademark Act in Nigeria. That's for Paul. So I think it's very arguable. It's very, very arguable. So that's on the one hand. But generally speaking, the question of the persona, the name, and all of that is a contractual issue. That's why you have to look at the artist as a product, and it's a contractual issue that I think it's a contractual issue that is best determined between the artist and whoever he or she is willing to contract with for whatever. So what does that mean? In some instances, on a platform, and the artist jumps on that label, the label can, give the artist that platform in exchange for certain rights. In some instances, and I don't think that has happened in Nigeria. So I don't think we have many instances of that. The label may even give the artist to sign up advance on the returns from his or her work. But it's contractual because the label has to make money. So the problems will arise where maybe the label is exercising undue influence, over the artist, or there's an imbalanced bargaining power or bargaining position in which maybe the artist did not and could not know better, and in that situation, mortgage his or her future, to the label. I think there's a precedent for that. It's involved King Sunny Ade. It's an unreported case, but you find that these issues between artists and their names is not limited to Nigeria alone. I took a particular interest. This is something I'm interested in. I think Marx and I, Chairman Marx and we had a conversation. We had several conversations about this topic many years ago, maybe like some 6-7 years ago, maybe like 6 years ago or so. Yeah, 5-6 years ago. And the need for Nigerian artists to start to treat their names as brands or as products. But that's that's a second leg to that conversation. Paul is talking about the artist even being able to use the name to even do the main thing, to sing, to perform. And I think everything boils down to your relationship with the label, and everything boils down to having good and quality advice, at the outset. And in rounding up, I will say this: Nigerian artists are terrible when it comes to. Hello?
Yes, I can hear you, sir.
In the music space, these actors, Nigerian artists, for those of you that are listening, they are all very terrible. Nigerian artists generally don't like, they don't get people in the entertainment space predominantly, especially in music. They avoid legal advice until something happens. And when something happens, they rush they look for free legal advice. And when they get legal advice and get a little reprieve, you will not see them again. They disappear at the first sign of some kind of results. So people in music in Nigeria, they have many bad habits, and it's the majority actually. It's only a few people that you see paying attention to the little details or the fine details. So I think there's a lot to be said about, have good advice. Not everybody can afford Juliana's services. Not everybody can afford Marx's services, but you will know a lawyer somewhere. Even if you can't get an IP lawyer or a cement lawyer, you can't afford lawyers like. But on a basic contractual level, one should be able. There are some things that should make sense, or not make sense. So I think Paul's heart is in the right place, but the world doesn't work like that, unfortunately. Everything works on the basis of what you are willing to give or to contract out, withhold. Thank you.
Thank you very much, Mr. Folarin, for your practical advice. Let's move on to Mr. Marx to also give his comments.
Okay, thank you, Juliana, and thanks to both. That was Paul, right? Paul and Rondo, right?
Paul and Brandon.
And Brandon, yes, for the wonderful presentations, and of course to Mr. Aluko. A lot of the comments he has made are exactly in sync with some of the issues I wanted to point out. So I'll just touch on a few other things. I'll start with Paul's presentation on artists and protecting their intellectual property, and I'll start from where Mr. Aluko ended, which is that particularly in Nigeria, and I re-echo what he has said. Artists are really terrible when it comes to seeking and utilizing legal opinion. They just assume, there's this thing about that star quality. You are up there and suddenly it feels like you are untouchable. You can never come down. Then, they just think they're invisible. So they don't need a lawyer. They don't need any advice. And then until things suddenly play out bad, and then, they want to go to social media with all the sub stories of, what the record label has done to them and all. But just to harp on that point also that Mr. Aluko had touched on, a lot of times what people don't understand with the music industry model is that when it comes to the music industry model, the artists really, with due respect to artists, the most important person in the value chain of particularly the music industry, for instance, is actually the record producer, because he's the one who takes on all the risk for signing you on, giving you some advance and all of that, hoping your music makes it to market, and then he's able to recoup his expenses. Of course, I agree that the Nigerian system is a little bit lopsided, or typically in Africa. In other jurisdictions, what happens is that record labels instantly start sponsoring you. They give you a house. They give you some real good money. So if your music doesn't make it to market, then that record label is actually losing on its investment. In Nigeria, I don't think the record labels give as much as they should at the get-go, but notwithstanding, I believe that artists should still respect the fact that music business is contractual. So if you have refused to negotiate your contracts properly or guard yourself properly in terms of intellectual property, then you should not come crying with sub stories when your record label decides to exercise their rights under your record contracts with them. But having said that, I'll point out a few stories also I think are instructive when it comes to the issue of protecting, artists and how they could use intellectual property to protect themselves. So we have the recent case of Omotola, who decided to trademark the name Omotola, and there was quite an uproar because people say, "Look, what if my name is Omotola? How is she trademarking that name, and I'm not allowed to use that name?" But what I always try to explain to people is that when it comes to trademarks, for instance, we have the same confusion with company name or your trade name and your trademark. Now, your company name, your business name, as registered under the relevant requirement of the law, is a name given to that business. So that's your trade name. It's quite distinct from your trademark. The reason is that your trademark is used to communicate, your products and services to the market, and to let the, and as an identifier, to let the market know that, goods or services or products are coming from a particular producer. So sometimes your name functions in that way as well, but it's not always. So there are lots of people called Omotola. They are all not using their names to make music like Omotola did, or to, act movies and to project a brand in the entertainment sector like Omotola has done. So I don't think it's unfair to allow an artist actually trademark, as it were, what sounds like a common name. It's particularly when there's evidence to show that over time she has invested in building a goodwill around that name. So the lesson there is that, and then I'll just correct a little in Paul's presentation. He used the word generic a few times. I think it was used a little out of place. Generic actually, when he was saying about Wizkid and Beyonce, that their names have become generic, I think it's the other way around. Generic is the opposite actually of what I suspect he was trying to refer to. Where a word is generic in a trademark sense when it's general, that's the easiest way to think about it. It's no longer unique enough to be used as a trademark. So when you say something has become generic, you mean it has become something that is general to a particular class, and no one person can monopolize it as a trademark. So I suspect what he meant was that Wizkid and Beyonce have become well-known names, or well-known marks, as it were, that identify the respective artists behind them. So, so just to bring that little clarification. And then I'll quickly touch on Brandon's presentation. Yeah, COVID-19 and IP is also, it has thrown up a lot of IP issues, particularly because COVID-19 struck at a point where the connection between IP and the evolution of online technology was heating up. So kind of interrupted that flow and threw up a lot of issues. But I think one of the very relevant issues, and I believe Mr. Folarin pointed that out, in respect of IP and COVID-19 is actually on patent rights for instance, COVID vaccine. So the question is, from a moral point of view, should IP law, patents now be allowed to create a monopoly for a few companies, to monopolize the market for COVID vaccines? From the viewpoint of how important this thing is for the public benefit, should a few people be allowed to do this? Shouldn't there be a need to issue compulsory licenses so that other manufacturers can produce COVID-19 vaccines to make it more accessible and affordable and available to, for public good? So a lot of countries I think have already done that, invoked that public policy element of a compulsory license to say, look, you must give a license. So, but the good thing about compulsory license is that it doesn't mean the producer or the owner of the patent is losing out altogether. It just means that you are compelled under law to give a license at a reasonable rate. So sometimes we talk about FRAN, that's free, reasonable, and non-discriminatory licensing, where you have to give a license at a rate that is determined, within a framework by the government and other relevant sector players, just to ensure that that technology that is critical to the public is made available. So I would only encourage Brandon to Google what we call the TRIPS. The TRIPS is the trade-related aspects of intellectual property agreement. It's one of the World Trade Organization agreements that has a lot to do with intellectual property. So if you Google TRIPS flexibilities, there's a lot of talk about the TRIPS flexibilities. Why is that important to Africa? Now, even if the African Nigerian government, for instance, or the Kenyan government gives a compulsory license to an indigenous Kenyan manufacturer, to a pharmaceutical company, to manufacture COVID vaccines. The next question is that, do they have the capacity in country to be able to manufacture, actually, to satisfy local demand? They don't. And under free or another compulsory licensing, Nigerian government will not give you compulsory license and then you go to India to produce. So under the TRIPS agreement, an arrangement was reached where countries that do not have the capacity to produce themselves, when they invoke the powers under their laws to issue a compulsory license, that compulsory license allows them, under the framework of the TRIPS agreement, to appoint even foreign companies to produce those products for those drugs for them under the compulsory license and export to their own home countries. So without these TRIPS flexibilities, even if African countries decide to trigger the compulsory license, they would not be able to produce these vaccines in the foreign countries or authorize foreign pharmaceutical companies to produce on their behalf. So I would like you to Google a little bit more read about the TRIPS flexibilities. I think it's called the, it was agreed at the Doha round of the TRIPS agreement, I think 2015 or thereabout. So read more about it. It will give you a broader context as to how African countries can benefit from compulsory licensing of COVID vaccines, for instance. So thank you, Juliana, and back to you.
Thank you very much, Mr. Marx. Thank you, Mr. Folarin, and thank you, Mrs. Uche in absentia, for giving your best to everyone here. I've learned a lot, and I'm sure that everyone here too have actually learned a lot. Thank you also to the mentees for coming early and for staying till the end. Thank you to the volunteer anchors, people who were with us during the last set, and the volunteer that they would also join us this set to also be anchors. So thank you, Bernice, thank you, Christina. And for next week, we will be having a guest mentor that will be talking about data protection and piracy and cybersecurity. So for every mentee here, your assignment is to go and read about it and have 2 questions each for the mentor that will be coming next week, Friday. Thank you so much and enjoy your weekend. Take care. Bye.
Thank you. Bye.
Thank you, Juliana. Bye.
Thank you. Bye.
Thank you
Okay,
very much.
thanks. Have a great weekend. See you guys next week.
You too, sir.
Thank you so much.
Thank you. Thank you. Thank you.